brothers and sisters. This is your brother Greg Ward, coming straight from the heart of Common Law Rights Society. Hope you guys are doing well. Once again, this is not legal advice. This is just your one brother's thoughts and opinions. All right, you guys. So I've been getting a lot of love for the Carlton Weiss readings from the Private Express Trustee Handbook, the Private Express Trust under the Common Law, and a lot of questions, a lot of thoughts. So yeah, let's just get into it, you guys. So I'm going to share my screen. Let's see if I can pull this up real quick. All right. All right, so check it out, you guys. This is just a simple template of a Private Express Trust that was made. This has been used. I use this in the DMV to register a vehicle. I'm not, again, giving legal advice. I'm not saying that you should register your vehicle under a Private Express Trust as far as registration goes. If you want to transfer the title, you can do that. That's fine. Once again, not legal advice, but as far as I can recall, when you transfer it, you're going to make your bill of sale, and you could make it from yourself as a private man into the trust itself, and you could say it's not, whatever you want as far as compensation or consideration. But so the idea is that you're going to be taking your private property, you're going to be transferring it into trust as the grantor to a trustee with the declaration of trust in hand, so the trustee can decide whether or not they want to become trustee or not, for the express purpose of the beneficiaries, for the benefit of the beneficiaries. Now, what role can the parties play? You as the grantor, you can transfer the property into trust for yourself to hold as the trustee for the benefit of some parties. So essentially, you'd be converting your ownership from outright ownership into the ownership, holding it under trust, under a declaration of trust. And at that point, if you want to get it, at the bottom of this trust indenture, this simple trust indenture, we have some places for witnesses to sign down here. So you'd have the grantor, the trustee, and some witnesses sign. And that's good for the sake of, especially if you're going to be granting it into yourself as the trustee. All right, so let's get into the simplicity of what you could put into it. So once again, all that's required is you as the owner to create this expressed trust under your common law right of contract without any kind of outside franchise or authorization. So you're going to be transferring this into the hands of the trustee, and it's a private contract. So there is no necessary outside parties to be deeming it as proper or whatnot. But just to tell you what happened when I brought this trust or something very similar to the DMV, and they asked, "What is it?" And I told them it's a trust, private trust, and they said, "Who prepared it?" I said, "I did." They said, "Well, it needs to be a lawyer." I said, "Well, no. Technically, it does not." I said, "I've created this before," and they said, then they sent it over to their legal department, and the legal department sent word back that the trust was perfectly all right. So again, all you need for a trust to be proper and lawful is a grantor granting property into the hands of a trustee for the express benefit of the beneficiaries, and that's all. That's all that's required. So, all right, let's get into it. Again, this is not legal advice. You don't have to copy this. This is just to show you something that I've done. Sorry, let me turn this ringer off or notifications off. Sorry about that, you guys. Hopefully I wanted to pause the video. All right, so check it out. We've got the date. We've got Declaration of Private Express Trust, organized under the common law right of contract without franchise from outside parties. Now remember, you guys, you could create the wording however you want. Don't take this as my, you know what I mean, this has to be like this. You're basically just stating the obvious. You're transferring property ownership into the hands of the trustee, and here's the obligations of the trustee, and here's the benefit of the beneficiaries, XYZ. And you can make it mold it into any shape you want. You could create it into a business. You can create it into, whereas the board of trustees would be basically the board of directors. They could hire out people to run the business, and it's for essentially the stockholders, but in this case, it would be the certificate of interest holders. You could have a private society like the Common Law Rights Society, where you could have myself as the trustee with information I place into the trust, and you guys are the members, and the membership is like the Freemasons or the Boy Scouts of America or whatever you want it to be. It literally is a society, just the same as Virginia, New Jersey, and New York. All these were societies. They were based upon trust indentures called the constitutions. And so you could create your own society within the society of where we're living. Anyway, you can mold it to any shape you want, but this is just one example. Sorry, I keep getting off the topic. Here we go. Declaration of Private Express Trust organized under the common law right of contract without franchise from outside parties. A declaration of trust made this day with a blank, so you can put in the date. I/we, my name, transfer all personal, private, legal ownership, titles, rights, and interests of the following. This would be where I would list property into the ownership of trustees named below. This is where I would name the trustees for the sole benefit of the following beneficiaries, members, subscribers who are not legal owners, partners, principals, nor agents of the trustees, nor do beneficiaries directly control any portion or management of the trust governance. So basically the idea is that the beneficiaries themselves cannot run the day-to-day operations of controlling how the trust runs. The trustee has to follow the trust indenture for that purpose, for the benefit of the beneficiaries. So the beneficiaries can't do things to cause the benefit of themselves. It's the trustee who has to do these things. Again, you guys can correct me if I'm wrong in the comment section below, but there has to be a separation of some sort, or otherwise it doesn't really make any sense. It's like outright ownership then. It's like if I created a trust, put my property into trust, I'm the trustee and I'm the beneficiary, then it's like I never parted from my property to begin with, and I'm utilizing it for my own benefit, the same as if I owned it outright. It doesn't make any sense. It doesn't use any portion of the trust law or trust principles. Anyway, so you're saying into the ownership of the trustees who are named below for the sole benefit of the following beneficiaries. So you can name the beneficiaries here down below. So you've got the original person, original man or woman who has the ownership of the property. It could be land. It could be a vehicle with a VIN number. It could be intellectual property, a song, a poem, whatever. Into the ownership of the trustees named below. It could be yourself or it could be others for the sole benefit of the following beneficiaries, which has to be different from the trustees. Now, if there's several trustees and there's several beneficiaries, and some of the trustees are some of the beneficiaries, that may be something that is looked upon as okay, but I can't promise that. I know that there is a want for separation of if you're creating a trust to have legal and equitable title. Sorry, you guys. All right, so duties and obligations of trustees. Now, the idea is Article 1, Section 10 says that a state cannot infringe upon the obligations of a contract. So that's where you want to be able to have these rights or these obligations. So it's an interesting dichotomy, if you will. It's an interesting split of thought. The obligations of the trustees are the things that the states can infringe upon. So you want to be able to put in here the things that really you want the trustees to be obligated to, as well as allow their abilities to get these things done with as much latitude as possible. Now, the wording I use in here might not be perfect, but you want to be able to allow for the latitude of the trustees to do the things necessary to fulfill the obligations So if within the obligation section you want to put they could travel wherever necessary within the union or within the world in order to accomplish the trust obligations, so on and so forth. Anyway, I may have not done this perfectly, and I'm sure it could be improved much, but this is, again, just a simple. All right, so number one, protect the trust property at all times. Trustees may utilize the trust property to further the purposes of the trust. Okay, so the purpose of that is to say that the trustees, that might be put under trustee rights, but protect the trust property at all times would certainly be an obligation. But the side note would be that trustees may utilize it. So if there's a piece of land that the trustees are holding for the benefit of the beneficiaries and they protect it, they could also utilize it. And you might work out a separate contract, as Carlton Weiss puts it in the one article, Trustees in Commerce. You might work out a contract with the trust as the trustee to show that you could use the land or the properties of the trust. Excuse me, guys, I'm a little bit out of it, I feel, today. And once again, hoping you guys are well, hoping you guys are safe. I know it's crazy times right now. But utilize these times to study, utilize these times to benefit yourself, to further yourself, benefit yourself for the benefit of the world, you know? You want to make yourselves better people. All right, number two, trustees shall distribute benefits that arise out of trust properties to beneficiaries from time to time as they become available, but shall not dispose of trust properties for distribution until trust terminates 20 years from this date, unless it becomes necessary for protection or expansion of trust assets. Now, that's a little bit wordy. I don't know if I would word it that way necessarily, but the idea is if you gain benefits, if you gain properties that arise out of the original trust properties, then you could distribute that from time to time. So if I had, let's say, some stocks or some kind of property that created some kind of income, I don't know what it would be, but if the original trust property created some other kind of benefit, let's say a piece of land that created a bunch of fruit and vegetables, and so those were benefits that could be distributed to the beneficiaries from time to time, but the land itself shall not be disposed of until 20 years from the date of this trust. Number three, expand the trust property when expedient for the benefit of the membership and beneficiaries. So expand the trust property whenever possible. That would be something that would be an obligation of a trustee. Number four, expand the membership of the trusteeship through whatever lawful activities trustees deem wise. So if this happens to be and this is what this was, if this happens to be a trust that creates a membership and a society, then the trustee can expand that membership with the trusteeship. If it's let's say, society of common law, people who love common law rights, the common law rights society, then the trustee, myself, can expand this trusteeship by expanding the membership. I could call upon you guys to join the society. Number five, trustees shall meet with membership minimum once per calendar year to account for the trust assets and new business. So that would allow for the trustee to travel, to go to meet with the membership. Trustee may not convert trust into an incorporated entity nor enfranchise trust with foreign benefit or license. This is basically saying the trust must remain a private express trust under the common law, and the trustee may not convert it into an incorporated entity or enfranchise it with any kind of foreign benefit or license. So basically keep it separate. Don't have it be anything that would bring minimum contacts in. Trustees will solely be identified to the public by their rightful status as trustees under obligation of a private express trust organized under the common law. Trustees function under the general law merchant and not through incorporated franchise. Trustees are obligated to identify themselves with trusteeship authorization. Trusteeship is not a creature of any foreign state, and trustees are not obliged to follow the statutory, admiralty, equity codes of any municipalities. Now, I don't know if this is worded perfectly, but you understand where I'm coming from when I speak all these things. And again, it should not necessarily be in the obligation section. It might be just a footnote or a side note or a note to law enforcement. I'm not sure, you guys, but you understand where I'm coming from. Trustees are bound only to the directives of this trust indenture and the fundamental natural law of the land, general common law, and the law merchant. Trustees shall never ask for or receive foreign franchise benefit on behalf of trusteeship. Trustees are obliged to travel by natural right Trustees are obliged to travel by natural right under declaration of trust and never pursuant to a foreign corporate license. I don't even know if corporate should be in there, but maybe benefit or license. Trustees will oblige him or herself to the beneficiaries at all times and shall not engage in activities that will hinder the fulfillment and performance of his obligations. Trustees shall travel when necessary and proper to fulfill the obligations of this trust. Number 9, trustees shall keep accounting of expenses of trusteeship, assets, beneficial interest, and shall keep minutes of meetings. Anyway, you guys, this is just what I thought would be something that would be nice to be in there. It could be something much more simple. You got the rights of the trustees. Trustees are authorized to travel anywhere by whatever lawful means are available to him or her without foreign state statutory license in order to serve the needs of the beneficiaries. Trustees are under a declaration of trust and are protected by Article 1, Section 10 of the Federal Constitution. Again, not necessary that you put this stuff in there because technically speaking, you just having a common law contract and a trust, all these things do apply. You don't need to have this in there. So I wouldn't necessarily put this in here, you know. This is more directive towards outside foreign people who are looking. Any restriction of obligations is a constitutional tort and will be prosecuted by any and all lawful means or remedies. So maybe this would be like this would be like something like that, and then maybe at the bottom. I don't know, maybe right here. Anyway, I'll just keep it in there for now. All right, so trustees are authorized to travel, contract, sue, defend, settle, purchase property, grow herbs, including cannabis and vegetables, create scrip for trusteeship, and any other lawful thing a natural man may do, sui juris for another. Now, this is potentially questionable, but basically the idea is, certainly a lot of it is not questionable, but the idea is that a trustee cannot be created for the purposes of unlawful means, and certainly not created to do a common law crime. Cannot be created to do a common law or civil crime. So the idea is that. And so now when you start to think about what is a common law crime, now you're talking about trespass or the destruction of other people's rights and contracts. When you're talking about civil crimes, you're talking about tort, and you're talking about, again, contract law. So now, as far as including cannabis, something like that, you know, that doesn't harm anybody. That's state to state. It's their statutory law that creates these types of laws or these types of codes. So a common law, is that a common law wrong or a crime? I would say not, because you're not harming anybody. But this is not legal advice. This is just what I put in here. Anyway, trustees may issue certificates of beneficial interest as well as scrip, which is basically money within the this is money to be used within the actual realm of the trusteeship. So if the four walls of the contract of the trust is the trusteeship, and that includes the lands, that includes the membership, includes the trustees, all the things that happen, all the actions within the actual realm of the trusteeship, and you decide you want to create a money for within that trusteeship, you're perfectly within your rights. Certificates of interest essentially are in and of itself transferable interest and therefore value. So that is in and of itself scrip. Trustees may issue certificates of beneficial interest, I already read that, as well as scrip for use solely within the jurisdiction of the trust or trusts created under the authority of this trust. So again, you can create certificates of interest or money to be used within the jurisdiction of the trust itself or trust that this trust creates. Actions of trustees to outside parties shall be considered as lawful within the trusteeship and not subject to legislative restrictions. Trustees shall have the authority to establish other private express trusts and other entities thereunder for the purposes of carrying out the purposes of this trust or purposes in conformity to this trust. Trustees are not liable for trust activities done in good faith within his or her trust duties or obligations. All parties shall look to the trust fund or other stipulation. So basically, that's stating that if anything happens as a result of the trusteeship, that the trustees shall not be liable, and that any property shall be looked to first, or any funds. All right, so then we have beneficiary rights. Beneficiaries shall have their exclusive equitable rights to the use of the intellectual properties contained within this trust, not to be used commercially outside of the jurisdiction of the trust. So that was, if I was to put in here a book or a song or something like that, this would be a equitable rights to the intellectual properties. That could be, you could remove intellectual properties and just put properties. Again, you could lay out different aspects of the beneficial rights. You know, they could have use of the properties on these days or these times or in these ways, or only these properties or only this aspect of the properties. Again, the beneficial rights could just be you guys participating and watching these videos. As long-winded as I am and as difficult as it is to get through sometimes. So again, you guys, you're very gracious in watching these videos. All right, so beneficiaries shall have exclusive equitable rights to the use of any lands or other properties acquired into the trusteeship upon request to trustees to schedule time in a reasonable time frame according to availability. Beneficiaries shall have exclusive equitable rights to the use of any other benefits trustees deem beneficial from time to time as they are made available from time to time. Beneficiaries shall have exclusive equitable rights to the use of the above items, as well as others that may be added, but never have a legal right to demand that trustees sell or dispose of trust properties, nor do the beneficiaries have any legal rights to control any portion of the management or governance of the trust. They are simply sesticade trust and are not and shall never be partners, owners, principals, nor agents of the trustees, nor shall they manage any part of the trusteeship. Again, they're just there to benefit. They're not there to run the trust. If beneficiaries have any grievances, they may in an electronic writing to Common Law Rights Society at gmail.com notify trustees of the issue, and trustee shall call for a meeting of the trustees if more than one and resolve the issue. There is nothing statutory about this trust and cannot be resolved by statutes or administrative court hearings for quasi-jurisdictions foreign to this trust. A common law court of equity is the only court that can hear cases regarding this trust. Again, I don't know, if these things are necessary or if they actually, will do anything necessarily, but the purpose is that a private contract like this lays out to the specificity exactly how you want the trust to look. So put in whatever you guys want. Purpose of the trust, generally the purpose of this trust is for the protection of private property and private rights of trusteeship membership, sustainability of the membership, expansion of the rights, benefits of the membership, creating a new model of a sustainable society within the exclusive confines of the trust, intersense, which just means within the trust, develop a stable barter system with script to be utilized intersense within the trust, to establish a 100% self-contained sustainable society created under declaration of trust, a unique juridical entity formed under the natural common law right of contract without foreign franchise. Non-commercial trust liability notice. As far as strangers to this trust are concerned, all decisions made by trustees are to be construed as final, and this trust shall be a non-commercial entity in relationship to all outside entities, since the trustee will not seek the benefit of becoming a corporation or franchise authorization to do business in any foreign jurisdiction. All business done on behalf of trust will always be within the confines of this trusteeship, intersense, within the trust. or between itself and other private express trusts, utilizing its own common law considerations. All right, so you guys, this is just how I put this one. You could create yours to be doing business. Again, any minimum context that you have with corporate America or corporate states will bring you potentially under liability. So this is particularly just done this way, particularly for a society that is to be run outside or within the other society of common law society, if you will, to be utilized as its own thing. So again, if I create this trust right here and place a Bitcoin or an ounce of gold as the consideration, as the trust property, and we never go outside of the trust to get any kind of outside benefit, then at that point we keep it strictly within the confines of the trust, and it has its own juridical jurisdiction. All right. Trustees are not to be held liable for trust activities done within duties or authorized rights, but all who engage with this trusteeship shall look solely to the fund or property unless stipulated otherwise. After trustee accepts the terms of this trust by signing below, he or she shall be obligated to this trust and shall rescind, cancel, surrender all municipal licenses from entities foreign to this trust. Again, this is just something I put in. Certainly don't have to have that in there, because technically, as soon as you take on, and this is my opinion, not legal advice, as soon as you take on the auspices of a trusteeship or a trusteeship position, then you can be in that role as you're utilizing, as you're tending to the trusteeship. This trust situs is domiciled in the Union of the American States, not a resident of any foreign or forum, FORUM, states, but operates out of private declaration of trust, serving the needs of the beneficiaries worldwide and throughout the Union. An unenfranchised natural citizen possessing all rights and immunities, trustees or trustee is authorized to do all things within good faith to promote the purposes of this trust, maintaining the trust property at all times and 24 hours a day operating under this declaration of trust. And again, the purpose of this is to basically state that the trustee is always to be doing good things within good faith to promote the purposes of this trust, and they're authorized to do all of those things. So your obligations extend outward to anything that any natural man may do, sui juris, travel the world, do whatever is necessary, contract, barter, trade, purchase, anything that a natural man may do. We're saying in this trusteeship that the trustees have absolute abilities to do those things 24 hours a day tending to this trust. And then this other aspect that I think a friend of mine helped put in there, spendthrift clause. It says no interest of any capital interest holder or beneficial interest holder shall be subject to sale, assignment, hypothecation, or transfer by any capital interest holder or beneficial interest holder other than in the exercise of an appointment power given to the capital interest holder or beneficial interest holder, nor shall the principal of the trust or its income be liable for any capital interest holder's debt or beneficial interest holder's debt or to the process of any court in aid of execution of any judgment so rendered. So basically, I think that's stating that no interest of a capital interest holder shall be subject to sale other than in the exercise of an appointment power given to them. So nobody else can sell that, I guess is what that's saying. And it's also saying that the principal of the trust or its income shall not be liable for any debt of the interest holder or the beneficial interest holder. So their personal debt will never become put upon the trust itself. Anyway, that's it, you guys. So sorry that was a lot longer than I thought it was going to be. But we've had some questions, and again, it can be so simple, you guys. It doesn't have to be anything difficult. Just put in exactly what you want. Exactly what you want, you guys. Mold your trust to be how you want it to look and how you want it to operate. All right? All right, that's about it, you guys. Have a great day. We'll talk to you soon. Stay safe. Keep drinking water. All right? One love. Peace and blessings.